Statutory provision related to mediation. Industrial Dispute Act Section 4 assigns conciliators the responsibility to mediate and settle industrial dispute and prescribes procedure in detail. CPC 1908, amended 2002, refers all pending court cases to mediation. Mediation for all family and personal matters. Companies Act 2013, Section 4, refers all disputes to mediation by NCLT and NCLAT. MSME Development Act 2006, mandatory mediation and conciliation when disputes arise. Hindu Marriage Act 1955, Special Marriage Act 1954. Disputes relating to marriage and divorce are more likely to be referred and settled by mediation. RERA 2016, Section 32G, dispute through ADR forum. Commercial Courts Act 2015, amended 2018. Mandatory mediation between parties before filing a suit. Litigation only if parties meaning fully engaged in mediation proceedings and still fail to resolve the matter. Consumer Protection Act 2019. Chapter on resolution of disputes through mediation. First, before approaching a consumer redressal agency. Role of mediator is to facilitate discussion, ask questions, reframe issues, assist to identify solutions, and assist in settlement. 6 stages of mediation. Mediation is the method of ADR when a third party who is impartial and neutral helps the parties in resolving conflicts by specialized mediation technique. Role of mediator: when appointed by court as mediator to air the dispute. Third, find out the strength and weakness of the case of either party. 3, agree on satisfactory solution which is beneficial for both the parties. 4, come out with a fair settlement. It has 6 stages. Mediator's opening statement: when both the parties choose mediation process to resolve their dispute, then mediator introduce everyone and explain the rules and regulations of the mediation process. Then disputant's opening statements. After being seated, each party has an opportunity to describe the dispute and its consequences. A process when one party is speaking, the other party is not allowed to interrupt in between. Then joint discussion. Mediator provides an opportunity to both the parties to put their case separately. 4th, private caucuses. Both parties have the chance to meet mediator privately in separate room, and mediator discusses the weaknesses and strengths of the case from both sides. 5, joint negotiation. After having private meeting with the mediator, brings the party back together to negotiate until they agree on any settlement for the dispute. Closure. 6th, after joint discussion and fair settlement accepted by both parties plus signature is written down and the benefits both. Mediation Manual, Supreme Court. Various causes of conflict and how to address them. 1, information, lack of information, misinformation and difference in interpretations. Strategy to resolve is agree on what data is important, agree on the process to collect data, and agree on the considering all interpretations of the info. 2nd, interest and expectations. 1, goals and needs. 2nd, perceptions. The solution is shift focus from position to interest, expand the options, find curative solutions, and clarify perceptions. Relationships. Then poor communication, misconception or stereotypes, repetition, negative behavior, distrust, and history of conflict. To solve it by establishing ground rules, improve communication, clarify misconception, agree on the process and procedure, keep your word, focus on improving the future, ignore the past. Structural conflict, resources, power and their constraints. Reallocate ownership and control, establish fair, mutually acceptable decision-making process, clearly define and change roles. Values. On different criteria for evaluating ideas and different ways of life, ideology and religion. On search for supraordinate goals, allow parties to agree and disagree, build common loyalty. The exercise, simulation number 5. The settlement made on this day, 8th March, between Mr. Aravind, Hyderabad, 1 part, Hyderabad Ventures, 2nd part, Silo System, 3rd part. Whereas certain disputes regarding IPR of software developed by party of 1 part, licensed and shared with the party of 2nd part, and allegedly stolen through an employee of the 2nd part by the party of the 3rd part, and the party of the 3rd part applied for a patent based on the same, is the base of the dispute. Whereas the parties agree to submit their dispute to mediation under ICADR rules of mediation. The parties have undergone the 6-step process as under: mediator opening statement, then disputing parties opening statements, joint discussion, private caucuses, joint negotiation and closure. Now the parties hereby agree to a settlement of the different aspects in dispute as follows, which is reported as under: 1. This is a court annexed mediation process. 2nd, mediator appointed by the court is so and so. 3rd, the dispute is referred to mediator as per ICADR rules and protocols and procedures. 4th, the place of mediation is Hyderabad City Civil Courts. Mediator's opening statement regarding facts of the case. Mr. Aravind is a software developer based in Hyderabad. He developed a software useful for private colleges. 2. He entered into venture capital finance arrangement with Mr. Hyderabad Ventures Capitalists along with non-disclosure agreement and an agreement that allocates software development duty to Mr. Arvind and patenting and copywriting and marketing and licensing responsibility to Hyderabad Venture Capitalists. Silo System acquired the program code created by Mr. Arvind and shared in confidence with the Hyderabad Venture Capitalists through the medium of an employee of Hyderabad Venture Capitalists by means other than those disclosed publicly. Mr. Silo Systems has applied for a patent to copyright on the said program with authorities who published the application on their website, from where a party of the first and second part came to know of their loss and raised a dispute. Opening statement of Mr. Arvind. I have developed a software for college management system useful for private engineering colleges and entered into agreement with Hyderabad Venture Capitalists for onward licensing, marketing and patenting the same. Mr. Silo Systems has however applied for a patent of a pirated version of my software and hence this dispute. Opening statement of Hyderabad Venture Capitalists. We have invested in software being developed by Mr. Arvind and agreed to put it up for patent, sale and license. We obtained a copy from him and were in the process of packaging it and marketing it before applying for a patent for the product. When we heard that Mr. Silo Systems had already submitted an application for patent of the CMS system, which bore an uncanny resemblance to our own product. On making inquiries, we found that one of our employees working in the patent section with us had passed on the entire code to Silo System, based on which they applied for a patent on a pirated version, hence this case. Opening statement of Silo System. We have been developing a CMS for quite some time and we employed one of our own experts as well as some outside experts. For the purpose of completing it, we have developed various versions of our software and the present version 3.5 has no code that can be claimed to be the same or similar to the party number 1 code. Our GUI of course bears some similarity as both of us are catering to the same colleges, same or similar needs. Joint discussion. On a meeting of all three parties, it was found that their CMS version 3.4 bore at least 35% common code as with their code of number 1, while version 3.5 CMS did not have any code that was similar to the main code. On further discussion, it was discovered that version 3.5 of Silos had non-literal components and GUI components which were very similar to the main program. Analysis by mediator presented to Silo Systems. In a private caucus, a discussion of the computer program was initiated by the mediator to clarify the situation and clearly indicate the abstraction filtration comparison AFC 3-part test to analyze the non-literal infringement claims in computer software. Refer the case Computer Associates International Inc. vs. Altair Inc. Defendant, USA 1992. Copyright law seeks to establish a delicate equilibrium. It affords protection to authors as an incentive to create. On the other hand, it must appropriate limits the extent of their protection so as to avoid the effect of monopolistic stagnation. Balanced view to be taken of literal aspect of the code and non-literal aspect of the code that are subject to piracy. Computer programming design. A computer program is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. The programmer works from general to specific. The first step in coding is to identify a program's ultimate function or purpose, that is creation and maintenance of the fees ledger example. Once this goal is achieved, the programmer breaks down or decomposes the program's ultimate function into simpler constituent problems or subtasks called the subroutines or modules. Updating a list of outstanding accounts receivable example. A subroutine may be broken down further into the subroutines. Programmers with this will then arrange the subroutine or modules with what are known as organizational or flowcharts. Flowcharts map the interaction between the modules that achieve the programmer's end goal. To accomplish, we must design each module's parameter. Parameter list is the information sent to and received from a subroutine. It refers to the form in which info is passed between the modules and info's actual content. With respect and form, interacting modules must share similar parameter lists so that they are capable of exchanging information. The function of the modules is a program. Together with each module, relationship with the other modules constitute the structure of the program. Structure may include a category of modules called macros. Macro is a single instruction that initiates a sequence of operations or a module interaction within the programs. Very often, the user will accompany a macro with an instruction from the parameters list to refer to the instruction. In fashioning the structure, a programmer maximizes the program speed, efficiency, user simplicity of operation, memory constraints used to run it. This stage of program design is in time and investment heavy. Once the modules are identified, design number, relation laid out, program structure finalized, embodied in written language called coding. Structural includes the source code. Second step is translate compiler into object code. After coding is finished, we will run the program to find logical and syntax errors. Then comes the debugging. Once this is done, the program is complete. In order to establish piracy, first step is compare word to word literal content. Second step, compare based on abstraction, filtration, comparison, AFC. Three-step test comparison is done in the routine, subroutine, module, flowchart, parameter list, macros, structure, program design level, and decide on the similarity and piracy. It was discovered by the above analysis that the 3.4 version had 35% literal sameness or similarity, and the version 3.5 had 0% common words, thus escaping the copyright violation charge. But the flowchart, program design, macro level, non-literal items comparison was more than 80% same or similar, thus proving the charge of piracy and subsequent modification of the code language and the coding per se. Individual discussion of the moderator with silo system. Moderator detailed the manner in which the AFC or the abstraction filtration comparison works to prove piracy and obtain their concurrence to the fact that their version 1.0 to 3.4 was a copy from the program of party number 1, and later on it was modified to consciously modify and change the literary aspect and words of the code so that it is not caught under the charge of piracy. Joint discussion. The party of the third part had now come round to the view that he should own up to the piracy background and offer to withdraw the patent application, allow the party of the second part to file a fresh patent application with a condition that he would get a license to the program to be used in his commercial activity. There was thus a commonality of mind achieved in all the three parties, and the mediation was successful and settlement arrived at and signed by all the three parties and mediator in witness to the settlement. The final report, which was success settlement report, was submitted to the court for it to provide a decree or a consent decree.